Thank you, Commissioner, my lord.
Thank you very much, Commissioners, for that introduction. Honorable Koech, we are going to engage you on your application that you made for the position of the Judge of the High Court. Please confirm to us your county and your ethnicity.
Thank you, Chief Justice. I come from Bomet County. I'm a Kipkemoi.
Thank you very much, Commissioner Macharia. We'll take it from there.
Okay, just a few questions, Mheshimiwa. I'm looking at your CV, and you've largely been in the judiciary, though you also with the Directorate of Public Prosecutions for, I think, 3 years?
Yes, my lord, 6 years.
6 years?
Yes.
All right. And then also, at some point in time, you're also in the private practice, though for not a long time, for a short time, right?
A short stint.
All right. Now, of course, you'll notice that you are many of you who have applied. There are many JOs who have applied, and also an equally big number from the private, from the private, the legal practice, and also in-house counsel. So you got to prove to the commission that you have something extraordinary that makes you suitable for this position. Now demonstrate to us what is that extraordinary that goes beyond the ordinary course of duty.
Yes.
And in answering that, avoid saying the general things that everybody says that they have, which ordinarily should have as a JO.
Okay.
Yeah.
Thank you, Commissioner. When I was admitted to the role of advocates in the year 2002, I had a short stint in private practice with a firm of Mulwa and Mulwa. And during that period, I also acted as a legal researcher to Justice, the late Justice Kasanga Mulwa, who was then a presiding judge in Meru Law Courts. So I got exposed to the workings of the High Court. My role was literally to research for him relevant authorities concerning the cases that he was then handling. And when I transitioned to the DPP, I was immediately deployed to the criminal division of the High Court, which was then housed in the current Supreme Court building. And I was able to handle several sensitive cases. Maybe I can mention two. I was able to handle, I was prosecuting murder cases, and I recall a case which I prosecuted, which was touching on violation of fundamental human rights. It was a case involving a young student, who was a student here at Kenya Polytechnic then, who had been arrested and tortured by administration police officers who were based at Ngara Chief's Camp. So I preferred charges of murder, and the case was purely circumstantial, and every hurdle was placed on my way. I was able to successfully prosecute that case before the Deputy Chief Justice Emeritus, Kaplana Rawal. Even though I did not get a conviction for murder, I got a conviction for the lesser offense of manslaughter, and the three officers were sentenced to serve 7 years imprisonment. So that is one area where I showed passion in my enforcement of fundamental rights. I also prosecuted a case where I preferred charges of murder against 3 officers who were serving with what was then called the Flying Squad, who had executed 2 youths in Kiambu County. The case was purely circumstantial, but I was able to demonstrate that they had the intent to kill, because part of the facts was that they passed through a center, they saw these youths who had gathered there, They drove for about 500 meters, made a U-turn, and when they came back, they shot at the boys and killed 2, the rest escaped. So it was also a purely circumstantial case. And we did not have then programs like the Witness Protection Program. And I had to use my ingenuity to protect the witnesses, telling them to stay with their relatives. And when they came to court, I persuaded the judge to hear the witnesses who I thought were critical. When I was posted to Nakuru, I was privileged to prosecute cases even before the court of the Honorable Chief Justice. In Nakuru, we were faced with a very difficult situation. There were a backlog of cases. Let me mention appeals. There were a backlog of appeals. And some of the sentences were served before the appeals were heard. We sat with the Chief Justice, who was the presiding judge, and other judges, and we formed the consensus that we had to do something about it. So I would prosecute murder cases. In the evening, I'm given records of appeal. I would burn the midnight oil, perusing the records of appeal. The next morning, I'll be ready. And I did not hesitate to concede in situations where I thought the conviction was unsafe. In situations where they appealed against sentence alone, I told the court, the judges, that they were at liberty to see if the sentences could be reviewed. We also did murder cases. Back then, Nakuru was covering the larger Rift Valley all the way to Samburu. And I was also able to coordinate those hearings. Back then, we used to communicate hearings through the provincial police officers then. I realized some of that communication was not reaching the stations. So I devised a system where I would write to the PCIO, copy to the DCIO, copy to the OCS, and copy to the investigating officer. And I also devised a way and got a dispatch system. So I would dispatch all my letters. And it resulted in a very effective way of availing witnesses. And we were able to hear many cases. To be quick, I was posted to Kericho to open the ODPP office. So I'm the one who opened and operationalized the ODPP office in Kericho. When I was posted, there was no office. So my brief was to scout for premises, to negotiate a lease, to get a lease, to partition and operationalize the office, something which I did. And back then, I was the junior most state counsel who was posted to the field station as head of station. And I successfully did my work there. Let me come to the period when I joined the judiciary. I was posted to Ogembo Law Courts for about 3 years. Then I was posted to Kapsabet for about 1 year. Then I was taken to Makueni as head of station. I was then 4 years old in the judiciary. So I was posted to take charge of Makueni Law Courts. When I arrived, I started the system from the registry and everything. What I realized was that it was like there were gatekeepers, maybe in the civil registry, criminal registry, and the rest. So after doing my studies, I did a reshuffle, and I had sessions with my staff. I told them we had to be open in our operations. Mm-hmm. I also started looking into issues which were challenging back then. One of them was a long-standing liability, deposits liability. So we had depositors who were coming to claim their money. They could not get paid because
I'm sure there are all those achievements.
Yes.
If we just summarize them, because I'm limited by time, what do you consider to be the biggest impact you've made as a judicial officer? Just, in under one minute.
Yes. I would say I've done my fair share of judicial work. If I would mention Makueni, I was a sole judicial officer for a very long time, for reasons that my deputy was transferred and the replacement did not come. Back then, my returns were almost double the national average for judicial officers. When I went to Maralal, I oversaw the construction of the new court building, almost to practical completion. And I was so happy when the Chief Justice opened the building. When I went to Eldama Ravine, I've also done my bit of judicial work and also administrative work, including constructing an ablution block, 4 units using 1.5 million, doing a stand, a water stand, buying tanks and the rest. I also did, when I went to Eldama Ravine, everywhere was muddy. I was able to pave the entire court using the little resources we get for maintenance.
Okay.
And our returns are good.
All right. Now, my final question, you've been a senior principal magistrate now for how many years?
I was elevated in the year 2020.
Okay.
So this should be my 4th year.
Okay. Yeah. Okay. So soon, at least, there would be possibility if you don't get this position of becoming a CM.
Yes.
Because it seems you've made very outstanding achievements, particularly on the administrative side of it. So, which brings me to the final question: would it then be appropriate, or okay? I don't know what you would say about that. If you could take a stab at that position, I can see you smiling, because you see the CM position also has a lot of expanded powers.
Yes.
Greater jurisdiction, so that you cut your teeth there first, you know, even in terms of also making substantial decisions. Because, you know, the position of a judge goes beyond, I doubt you'll be taken into administration, because, see, the beauty of it, as a judge, you'll have the head of the station who handle most of the administration. So what you're looking for, the preference is for somebody who can, you know, determine disputes, because that's the core work of a judge, as opposed to administration. Now, being a CM, it gives you a very good possibility, a wide possibility of hearing these disputes, that expanded jurisdiction, determining them, and you know, developing most jurisprudence at that level. Then you can take a stab at as a judge. I don't know what you'd have to say about that.
Okay, thank you, Commissioner.
Yeah.
As I pointed out earlier, I spent 6 years in ODPP. I'd actually risen to the position of senior prosecuting counsel, but when I had a passion for judicial work, so when an opening came with judiciary, I took a lower rank as a resident magistrate. So most of the CMs who are within the institutions currently are my contemporaries in terms of admission and work experience. And in terms of exposure, having worked with the eminent judges, who I have mentioned a few, and when I was in Nakuru also, I had an opportunity to appear before the Court of Appeal. I handled appeals before the Court of Appeal. So at that level, again, we were reviewing the decisions of judges. So I'm judge ready. And in terms of judicial work, I've done so much. Yes, thank you.
Thank you very much, Honorable Chair. Honorable Koech, a few questions from me. When I worked in Kitale as a magistrate, we had many people who used to cross the border from Uganda to Kenya, and they would be charged with the offense of being illegally present in Kenya. I don't know whether you get them in Eldama Ravine.
No, we rarely get them, but when I was in Maralal, we used to get those who were traveling from Ethiopia.
Oh, okay, and they would be illegally present in Kenya.
Yes, they were.
So at the end of the day, what order or orders, after you found them guilty of the offense, what order or orders would you make?
In some cases, if they do not have the status of refugees, we would order extradition back to their country.
Let's be very careful with the use of words.
Yes.
So you're saying those that you would find illegally present, you would order extradition?
After, if there would be a sentence preferred, then, and if they are not in the category of refugees, who should be protected under the regime of refugee law, then we used to order extradition back to their country after service of sentence.
So that brings me to my next question, actually.
Yes.
What is the difference between extradition and deportation?
My lady, okay, I stand corrected. Actually, the right term would have been deportation to their country of origin.
All right.
Yes.
So those ones who are illegally present, they would be deported
Back to their country, yes.
back to their country.
Yes.
And you are the one who has brought out the terminology extradition. So I would like you to differentiate the two terminologies, extradition and deportation.
And deportation.
Yes.
Extradition touches on arrangements between countries, probably defined by conventions and treaties, where they would have mutual programs for extradition of people who commit crimes in one jurisdiction and are probably in another jurisdiction. So they would seek that this person be extradited to the country where they have committed a crime.
You're very right.
Yes.
And
deportation now is maybe this could be somebody who has not committed a known crime, but happens to be within the jurisdiction of one country.
So you see why we have
permission.
to be very careful about our choice of words.
Yes.
In extradition, one has committed a crime in another country,
yes.
But in deportation, there is no crime
There
that
is
has
no
been
crime.
committed.
Yes. You're right, my lady.
Right. What about repatriation?
Repatriation. I think repatriation would be somebody who was probably initially admitted into the country, maybe coming by use of a visa, but probably the status has changed and is being repatriated back to their country.
Why is he being repatriated?
It could be...
The first one, deportation, you found them guilty, they have not committed a crime on the other side. Extradition, they have committed a crime on the other side. And what about repatriation?
If I get it right, probably maybe they have outlived their stay, maybe the visa is expired.
And how do they go back?
It's almost akin to deportation again.
Deportation is forceful.
Yes.
Repatriation is voluntary.
Okay.
They agree that we are going back home.
I stand corrected. I'll check up that.
No, but you've done very well in respect of the other two. Now, in the area of company law,
yes.
When is the veil of incorporation lifted?
I think it's done on application.
Yes, on application?
Application by probably a party who would want to know the ownership of the company and the directorship.
So, to your understanding, what is it that is meant when it is said that the veil of incorporation has been lifted?
At times, in some companies, maybe the persons running the company and who are projected are not the real owners. So when you lift the veil, you are literally going into the inner sanctum of the company to know who are the owners of this company.
So it is to determine the directors of the company?
Yes, and ownership.
I think you need to check on that.
Okay.
But that's all right. That's all from me. Thank you.
Thank you. Thank you, my lady.
Thank you. We will continue with the conversation to test whether you are judge ready, because that's what we are looking for. And so I will ask you a question on the interpretation and the application of the Constitution.
Yes, my lady.
If a petition is made before the High Court seeking to disqualify a person who is vying for the position of the MP,
Yes.
on the basis that they do not qualify, what will you look for? At least 3 things that you look for.
Yes, thank you, my lady. I would check if he's a registered voter, which is one of the requirements to vie for the office of Member of Parliament. I would also check if he's a citizen of this country, which I believe is one of the other requirements.
To be registered as a citizen, as a voter, don't you have to be a citizen? So that's one and the same.
It's one and the same thing.
Yes.
Yes. I would also check if he has the minimum qualifications to vie for that office. And the Elections Act would be of guidance. And which should be the third one. Maybe I need to check on that.
You need to check on that. We can now move on to the area that you have been practicing. If an application is made to strike pleadings, what do you look out for before you strike out the pleadings or allow the striking of the pleadings?
Okay. Application to strike out pleadings. Maybe it's a broad area, but I would check if the application is grounded on the fact that maybe some is joined of parties. Maybe I would need to review the pleadings to see the party against whom the application is made was suing under what characterization. If the application is made to strike out pleadings, let's say for instance that the matter is res judicata between the parties, then I would need to review the circumstances under which that plea of res judicata is being raised. But generally, the Constitution requires us not to look into most of those technicalities. Maybe there's some pleadings which would appear like they were not properly drafted, but I think those ones can be cured by way of amendment.
Okay, so I think the first thing to look at is the defense, whether there is a defense on record. Yeah?
On record, yes.
Yes, Justice Majanja.
Good morning.
Good morning, Commissioner.
Can you tell us what is the importance of foreign authorities and how far can we rely on them in judicial decision making?
Okay, thank you, Commissioner. I think first as nations, we are one humanity. So at times you can find authorities which are, even though they were delivered in a foreign jurisdiction, that would be equally applicable to our circumstances in Kenya. Let's say probably if there are authorities on enforcement of international treaties or fundamental human rights, or in the nature of international crimes, then I believe they would be of guidance. But we now have to put the constitutional test whether it also conforms to our local jurisdiction and our laws.
Okay. Tell me any one decision from South Africa you're aware of that has been relied on by courts in Kenya?
I may not remember the citation, but I believe I remember some of the considerations. the citation escapes me, but it was something challenging the decision of the executive arm of government, almost akin to...
Any decision from the US, that we have relied on?
I would recall probably Marbury versus Madison.
What was that case about?
It was concerned with... It was also, I think that it's the father of judicial review. It was, the applicant was somebody who was appointed into office in a transition period. His commission could not be delivered in time. So when the new administration came, they sat on that commission. And when he moved the court, I think the finding of the US Supreme Court was that he was lawfully entitled to get that commission.
So what principle did that court espouse that we have followed?
I think one of the principles was that of... there were a number of principles which were exposed, but the one I recall is that in appropriate circumstances, the court can call into question the acts of probably state officers, if I may use that word, if they were not done in a constitutional manner.
Okay, thank you very much.
Thank you.
Thank you, Chair. Good morning once again, Your Honor.
Thank you, Commissioner.
And thank you for welcoming us very well when we visited your station. And I do confirm you've done a good job in terms of improving the dignity of the court users by setting up the abolition block.
Thank you, Commissioner.
Under the Capital Markets Act, insider trading and front running are listed as market abuses. Do you know what insider trading is and what front running is?
I didn't get the second length of the question.
The Capital Markets Act lists insider trading and front running as list of market abuses. What is your understanding of insider trading and front running?
Okay, let me try to define insider trading. Insider trading would involve misuse of information which someone receives by virtue of the office. Let's say if you are a regulator, you have information that may affect probably the operating environment of the market, and then this information is passed on to other actors to capitalize on that information, so that it gives them an unfair advantage over their competitors. And that one would amount to insider trading. Front running, I may need to check this one.
Okay, yeah, there's a thin line between the two. And I have just gone through your certificates. Among the trainings you have undergone is on transnational crimes.
Yes.
What is the difference between smuggling of migrants and trafficking in persons?
I would think the two offenses could be interrelated. At times, smuggling is done by operators who would want to connect migrants to their destination, their desired destination, probably by going through administrative hurdles. So the migrants would probably pay the smugglers, and then they will take them through informal channels to their destination.
Can you smuggle a resident of Busia to Nairobi?
It has to be cross-border. It has to be cross-border.
Okay,
Because
that
the
is one of the
resident Busia would be free to travel to Nairobi.
Okay, okay.
Yes.
And trafficking in persons?
Trafficking in persons, if I may distinguish, it might even involve involuntary victims, like children, women who are probably literally taken hostage and transferred across international boundaries again. Yeah.
So again, there is the element of international boundaries.
Yes, again.
Can you traffic a person from Busia to Nairobi?
Maybe I need to check that.
Okay,
Yeah.
okay.
Yeah.
Thank you and all the best.
Thank you, Commissioner.
Good morning, Mheshimiwa.
Good morning, Commissioner.
I also want to join my colleague in thanking you for the warm welcome you gave us when we came to your station in Eldama Ravine.
You're most welcome.
Yes. So, to start off, we have Order 11 of the Civil Procedure Rules.
Yes.
What, in your view, was the rationale behind Order 11?
I think the rationale of Order 11 was to bring parties to parity, and it was born out of the experiences we had where parties would file pleadings, probably they don't exchange pleadings, they would file documents and probably serve the other party and exclude the documents. So Order 11 came in to cure that mischief, so that when you bring the parties together, you are able to ascertain if everything has been exchanged, if disclosure has been done, so that you can certify the suit is ready for hearing.
Was that the sole purpose for Order 11, and is that all it seeks to achieve?
Not really. Another,
Yes.
I think another object of that order is for the court also to be seized of these matters and to take control even in terms of the expeditious hearing of these matters. Because once you certify, then you give dates and you take charge as a court.
Okay. So you have applied that order severally as a judicial officer.
I have.
So could you just walk us through the process that you normally undertake to comply with Order 11 in your court?
Okay. Normally at the close of pleadings, you give the parties a mentioned date for purposes of checking compliance with Order 11. So when the date materializes, you now check. You ask the parties if they have done discovery, if they have exchanged documents. You can actually probably also ask them if there are documents which can be admitted by consent, if there are expert reports, if they can be admitted without calling the authors, so that it would also inform you. Because when it comes to listing also, you list a number of cases that can be reached. That one can inform you. You also find out the number of witnesses that they're likely to call.
And then that's all. At what point do you explore the possibility of making a reference to ADR?
I think it will still be an opportune moment at that level. But
And when do you discuss the issues for determination and see if you can narrow them down?
it's part of the requirements under Order 11.
Oh, okay.
They have skipped my mind. Because
Okay.
they're meant to draft the issues,
Mm.
and if they have not, then the court can narrow down the issues for determination.
Okay. The other issue I want to discuss with you concerns your report from DPOP. I believe you got a copy.
I got a copy.
Okay, and it's accurate?
I think it's accurate in terms of capturing what we did.
So it tells us here that you are not exactly meeting expectations in terms of your output in the total resolved cases of the court. You are expected to carry 50% of the weight, you're only carrying 44. So you are lagging behind by about 6%. What is the challenge?
I've had a long-standing challenge, especially with criminal cases. My prosecutor has been unwell, and she's missed in a number of court sessions. So we've had to share one prosecutor, both courts. But in those circumstances, I would probably use the prosecutor to hear cases which we would prioritize, maybe erecting vulnerable witnesses and the rest, and then you would yield the prosecutor to the court where she is. It's a challenge that we are trying to address. I've taken up with the OTPP, and I think they've even posted an extra counsel.
Okay.
That could, yeah, that is the main impediment.
How many cases do you have pending that are of civil nature? Roughly, if you are to estimate. I know you can't give the exact figure, but if you are to estimate.
I may not get the exact figure. I had a copy of the returns, but I didn't carry. But it would be maybe around...
Or you can give a percentage if it's difficult. What is the percentage of civil cases you have vis-a-vis criminal?
Maybe I would say around 40.
40% civil,
Yes.
and 60% criminal.
Yes.
Then maybe you may consider rearranging your days, the days when you sit on the civil bench, so that you can be able to share that one prosecutor,
Yes.
and be able to be efficient in the discharge of business than sharing and waiting the same prosecutor who is not available. And that would improve your case clearance rate.
That can be a practical solution. But I'm happy that they posted somebody. He had not reported by the time I left the station.
Oh, okay.
But we can rearrange so that I'll tap into the other prosecutor when my colleague is doing civil. But that's what we have been trying to do also.
Okay.
Yeah.
Thank you. I wish you well. Thank you, my good.
Thank you very much, Honorable Chair. I have one or two questions, Your Honor, very briefly. Now, do judges make law, and how far should they? How far should the judiciary stretch into the territory of Parliament?
Thank you, Commissioner. Yes, my answer would be yes. They do make law, because the Constitution itself donates the power for them to interpret the Constitution, to interpret the statutes, and to breathe life to the Constitution generally. So there could be some areas which the law has not clarified. So a judicial decision can cover those areas, because even in interpretation, one is required to give effect to the law, if it's fundamental rights, to breathe life into them. So that would be a decision which might cover an area where the statute does not provide, or it could be a decision interpreting a statute where there is no consensus on what it means to several actors, maybe executive vis-a-vis parliament. Lawmaking itself is a preserve of the legislature, and exactly under Article 2 is a preserve of the legislature, but those laws also have to conform with the dictates of the Constitution, and they also have to take into account the fundamental rights and the Bill of Rights.
My second question is on leadership. Would you just tell us the responsibilities of leadership in Chapter 6, and please share with us a scenario where you made a decision, a leadership decision, or you distinguished yourself as a leader. Just one, and very briefly.
Okay, responsibilities of leadership. I would say leadership in itself is a public trust, which should be used for the good of society. We are required to work as servants of the people, so to speak. That's what the Constitution says. We are required to insubordinate personal interest for public interest, and we are required to be honest in the discharge of our duties. We are required to be truthful, even with information we share with the public. How I've distinguished myself as a leader, I would have many examples, but probably I would use a few. Okay. Let's say on the side of integrity,
Practical example, where you really, demonstrated your leadership competencies.
Okay, thank you. When I was posted to Maralal in Samburu, I found a situation where we had to deal with crimes which were commercial in nature, but which were endangering our environment. We had to trade in endangered species which are protected even under international treaties, like the East African sandalwood, and trade in wildlife trophies. So what I did as a court, and I'm a passionate environmental conservator as a person, I brought together all actors, and we formed a near consensus that we had to fight those vices, and we did exert ourselves in that fight by expediting cases that had been brought to us, by securing those exhibits, especially sandalwood. We had a situation where they would just disappear in the police station. So as soon as a case was done, we would order their immediate destruction. It was running into millions. I think that's one area where I demonstrated leadership, and it came at a cost. At some point, the actors in that business singled me out, and the county head of Nice and the county and the DCIO, they singled us for physical elimination, but we stood our ground.
Thank you, Honorable Chair. Your Honor, I have a few questions for you. Now, the institution has, under the leadership of the Honorable Chief Justice, has gone big on the use of technology to facilitate effective and efficient access of justice for all. Would you please tell this commission what role you're playing as an individual and as the head of station to ensure that you've embraced the use of technology?
Okay, thank you. Thank you, Commissioner. What comes to mind is our virtual hearing of cases, where we are deploying technology. A party who could be in Nairobi is able to log in and prosecute their cases. A witness who is even outside the country is able to log in and testify. So what we did post-COVID period, we started embracing virtual hearings in both civil and criminal matters. It has its own challenges, especially on issues to do with connectivity, but as we speak, almost every expert testifies virtually before our court. We agreed as a CUC that probably the prosecution would bring the original documents and they would share a soft copy with the expert. Then the expert would log in and testify virtually, and then the hard copy document would be handed over to the court. So that is one area where we are utilizing technology to broaden access to justice.
Thank you. How would you rate your uptake of technology, especially the virtual, running your court virtually, in the scale of 1 to 10, 10 being high, 1 being the lowest? How would you rate it?
Commissioner, maybe I would put it at 8, and the missing 2 is for reasons of capacity and technology downtimes. But ab initio, we have deployed the technology for use, and as a person, I use it even when I'm outside court, like when we are attending the mobile. I use my hotspot and my personal data.
So you'd call yourself a champion of the same?
Yes, I do.
Okay. My other question is, what is emotional intelligence?
Emotional intelligence, Commissioner, my understanding would be somebody's reaction to challenging situations. Let's say you are in a situation where something needs your decision, and maybe it's an issue that could be affecting several people. Let's say, let me use this example. At times we have litigants who would demand service like now and no other day. So emotional intelligence might mean your response to them by explaining maybe the processes and promising to look into their issues as soon as possible rather than that confrontation. So you'd have told them, calm down, I'll look into your issue. Maybe that's one example I can get.
Okay. The explanation there is not quite clear, but I will take it. Maybe you can demonstrate to us a time you have used emotional intelligence in your role as a leader.
In my role as a leader?
Yes. One incident that is big that comes to mind.
Let me try to think about... I think even the cases I mentioned, which I prosecuted in Nairobi, where you have a situation of vulnerability of witnesses, but you're still able to advise them to take caution. You're able to line them up to testify at the earliest opportunity, so that you remove the threat of elimination. I think that could be one example that I can give.
Okay. Moving forward, I have a document here, a complaint against you by one Vena Lorraine Achieng, who challenges your suitability for the position of judge. It's a complaint that the commission wrote to you to give your response, and I will just briefly take you through it. She says that you made some malicious remarks about her, and I will name some of them, some of the things you said, or that is alleged that you said. You said that the council was notorious, she had notorious pretense to be ill to avoid work, preference for virtual court, which you would never accept, non-appearance to the ODPP office for work, failure to attend CUC meetings, inability to perform since prosecution counsel are both women. You also issued threats to write to the DPP for a replacement of Prosecution Counsel in Eldama Ravine. Allegations that the head of county, also a lady, dismissed your complaints. Failure to attend to investigations and other persons requiring our your services of the court, and then failure to physically attend mobile courts. Now, you made these remarks about the counsel who says she had been unwell. She had communicated the same to you, and on several occasions she had to seek, a private room within the hospital just for her to attend to court sessions. She says that she feels this was malicious, and some of the issues that you raised were not true, and it affected her, even in her illness, that you were not understanding. Maybe you could briefly tell this commission what was that about, and how, if there's any other way you'd have gone around this issue, considering that this officer was unwell.
Okay, thank you, Commissioner. And I also thank the Commission for bringing the complaint to my attention and granting me the opportunity to respond. I've made a comprehensive response to those issues which she raised, but I would still explain the circumstances that were there. Her complaint touches on a letter which I wrote on 13th of March to the regional head of ODPP, and I would explain the context under which I wrote that letter. On 11th of March, I was the duty court, and I was the only court sitting in Eldama Ravine. So I made arrangements to arrive in court early. It was around that period when there was a national crackdown on illicit brewers, traders in second generation alcohol, and people who are generally not in compliance with the Alcoholic Drinks Control Act. So I knew we were likely to get several pleas. So I arrived in court early. By the time I wanted to start my session, then my court assistant told me there was no prosecutor. I tried to reach Madam Vena, but she did not pick my calls. I tried to text her, and she did not respond to the text. I was running late in my court sittings, so I called her deputy, and she told me she was on her way coming, and she requested we start court sittings late. It was around 10, because she was still on the road. So I waited, and then she came. So I was able to mention two matters. My deputy actually taken a sick child to hospital, so I had excused her. So I mentioned two matters. I took the pleas, and we did the hearings with the Kotu prosecutor. And that day was settled. The next day, which was 12th, I woke up again to report for duty. When we wanted to start court, there was no prosecutor. And I tried to reach Vena, who was prosecuting in my court. And she had switched off her phone. I could not reach her. I tried again to call the prosecutor court too. She was not in the office, and she had switched off her phone. I had a situation where accused person, litigants, and witnesses were in my court. So what I did was, I went to court, and I just told everybody that it appeared we were going to start our sessions late, because I did not have a prosecutor and I could not reach them. So I went back to chamber. I was now trying to, it was developing into a crisis. I could not get information as to why there was no single prosecutor. I knew the head of OTPP Kabarnet, the county head, was somebody called Mongare, but I did not have his contacts. So I sought the contacts from the immediate predecessor of Fena, somebody called Benjamin Kelwan. I called Kelwan and I told him to give me Mongare's contacts. And he tells me Mongare has been transferred from Kabarnet and there's a new county prosecutor called Claire Koske. He gave me the contacts of Koske, but he also told me he was attending a training at Kenya School of Government with Koske, with the rider that they were in a break. So I immediately called Koske and Claire Koske. I was calling Koske to probably request her to send us a prosecutor from Kabarnet and to probably inquire why there was no prosecutor in my court. So Koske tells me, I'm attending a training in Nairobi and I have no spare prosecutor in Kabarnet to send to Lama Ravine. I think one prosecutor was Anwar, another one was on leave. So Koske gives me the contacts of the regional coordinator of OTPP, somebody called Hassan. I call Hassan, and I inform Hassan there's no single prosecutor in our courts, and I can't reach any. They've switched off their phones. He even tried to call them personally, and none could be reached. So Hassan decided to travel from Nakuru to our court, some distance of about 50 kilometers. When he was still on the road, now Vena texts me to tell me, can we handle matters virtually? And she said, let's proceed off camera because I'm not dressed for court. The answer I gave her was, it's okay, because at least I wanted to release the litigants. I realized all the matters were collapsing. So when we were arranging now to start virtually, I called Hassan. I told Hassan, you don't need to come. You don't need to travel from Nakuru to my court. I've been able to make contact with Vena, and she has agreed to handle matters virtually. But he told me I'm on the road, and I want to come and check what the problem is. So I told him he's welcome. So we proceeded virtually. We literally took out all the matters for the day. And then when Hassan now came, he told me I had to put into writing what the problem was. I did a letter which I sent a copy to the commission. And everything I stated in that letter was factual. It was factual that Vena had failed to attend court several times. I was aware she was sick, and I was one of those people who checked on her severally through text messages and calls. We made an arrangement where if she's unwell, we would handle matters virtually. So I mentioned that she was unwell. I mentioned that it had reached a situation where she does not communicate to me. Previously, she used to communicate perfectly. I'm unwell, I'm not able to come. She would text or call. But it reached a situation where communication dried out, and at times now when I call, she doesn't respond. And she started now communicating through my court assistant. So if I want to rise and sit in court, and the court assistant will tell me she's not there, she's appearing virtually, then we would make arrangements. So I mentioned that one in my letter, factually. It had also reached a situation where no prosecutor was attending our CUC. I mentioned 3 meetings, and I attached copies of the CUC minutes and the attendance list. So in a CUC setting, some issues will be directed to court, maybe from one of the stakeholders. In a situation where there's no single prosecutor, people were raising issues, and I kept telling them, now those issues, let us wait for a situation where there would be a prosecutor. And then so I attached minutes. She even seems to dispute those obvious facts, like the fact that they were not present in 3 meetings, and almost consecutive meetings. And you know, it's an important organ of management of court. It's a mini version of the NCHA. So I mentioned all those, and Hassan insisted for him to take action, I had to do a write-up. So this was a situation where you are damned if you do, you are damned if you don't. And he specifically mentioned to me that the ODPP was going to attend a function in Eldoret which was hosted by Justice Ruben Nyakundi. I think the next day or a day after. So he wanted this letter so that he would address the issue when he's with the ODPP in the sidelines of that meeting. That was the context under which I wrote that letter.
That's understood, Honorable Koech, and it's good to put some of those things in writing so that then there's a follow-up. But before it got to the point where you are involving the team, Hassan and team, what had you done about this officer, knowing that she was unwell, knowing that she had communicated to you, knowing that it's possible at the time she told you she was not dressed for court, she could have been in hospital and not able to appear in the gowns, I am assuming. What did you do about that situation?
I had actually understood that she was unwell. That is why I had made all those accommodations. We could sit in a physical appearance and then she would ask for a health break and I would give her. We would be in virtual and I would give her.
Had you taken any?
She had told me she had requested a transfer on health grounds. I even quoted the text that we exchanged. So I knew there were arrangements for her probably to go to a station near her home. And I'm even one of the people who advised her to seek a second or a third medical opinion. And
that's okay, Honorable Koech.
Yeah.
That is okay. I'm asking, what did you do to avert a crisis? Because you knew the prosecutor you were dealing with was unwell and she had health issues that could hinder her performance and her appearance in court. What did you do to prevent a situation where you're in crisis? Because now what you were dealing with, what you were fighting with was a crisis. You are trying to cover up in times of crisis and you're working now out of pressure.
You see, there was now this promise that somebody who was replacing her was in the office. If you see one of the texts I've quoted, she didn't tell me within a week. So I was thinking the situation was being resolved by the office. And I had also been told that the ODPP was doing recruitments. So part of the understanding that we had was that within time they would deploy, and they have deployed. I was now faced with a situation where I understand somebody is unwell, and we did proceed with some of the matters virtually, but there is no time that I ever forced her to proceed when she's unwell. And I think she was dishonest when it comes to that point. She brought in issues. You see, like Claire Koske, I only talked with her once, and she's trying to show like I discriminated her because she's a woman. But my concern was work, and I'd said it was affecting our performance.
I think it's okay, Mheshimiwa. I personally understand your situation. Yes. I would not do it differently from what you did. I think it's okay.
Okay.
Because you know you are balancing also between also the other stakeholders.
Yes.
And she was also under obligation to also let you know, at least even by a text, you know, so that, because you have other people that you have to attend to. You have the members of the public, you have the lawyers, you have everybody.
That's true.
So you see, faced with that kind of a situation as the head of the station, where you're under pressure, sometimes, you know, we also blame judicial officers and judges when they are put in these kind of circumstances. And you have to deal also with many other situations. So for me, I also understand where you are coming from.
It was a very hard decision.
Yeah, so you don't need to apologize too much about it.
So to put this matter to rest, do you think there's anything you'd have done differently in this case of the officer?
maybe I would not have written that letter, but Hassan insisted. He really insisted, and the next day he was with the DPP in Eldoret, hosted by Justice Nyakundi. He's the one who insisted. I actually called him and told him it's like he was setting me up.
You know, I don't think you should even apologize for writing a letter, because that is the way we communicate. In fact, our problem stems from the fact that people refuse to document what is happening in writing.
Yeah.
In fact, immediately this issue arose, you should have put in the letter saying, this is the problem I am facing. It is precisely because we all are afraid of, this and that, is that why we get into problems. But you did well, you've dealt with the situation, and thank you.
Thank you, Commissioner.
Thank you.
Thank you, Vice Chair. Thank you.
Thank you. Thank you very much, Commissioners. And I think thank you very much for encouraging Honorable Koech to continue being hardworking, focused, accountable, and firm, with the position that you have been given. I think this brings us to the end of the interview. We always give a candidate, Honorable Koech, an opportunity also to engage us if you have a question or a comment. But what I would like to say on behalf of the commissioners, we wish you well and encourage you to continue being firm and working. Personally, I worked with you in Nakuru, and I know you are very hard-working officer, very focused from the work that we did in Nakuru, and that we appreciate. You have to keep running your court. We talk about shared leadership. You have to discharge your responsibility by being independent and being accountable. Yeah.
Thank you, Chief Justice. Mine is to thank you and the Commission for the opportunity to come for this interview. To me, it's a great honor, even to appear. And I really thank you, and I bring to court to give leadership to this commission, which is doing a great role in our arm of government, which is the judiciary, to give you wisdom and good health. Maybe what I would request the Commission is, if it were possible, to post ICT officers in all stations. At times when we face challenges, and you are relying on officers who are working far off, by the time the intervention is done, services have been grounded. So maybe in the fullness of time, the Commission can consider posting ICT officers in all the stations. Yeah.
Thank you very much.
So much.
That is also noted. We wish you well. We'll communicate with you when we complete the exercise.
Thank you so much.
Take our greetings to the people of Yondama Ravine.
I will.
Yes, and tell them the Commission appreciates the warm welcome you gave the members when they visited the station.
It was well deserved.
Yes.
Thank you.
Yes, thank you. Have a good day and a good weekend.
Thank you.